Very good afternoon to everyone. It's a pleasure having you all on board. I, Pooja Malwanki, Assistant Professor, Department of Botany and Mentor-Mentee Coordinator, IIC, KLE Sajalapura Science Institute Autonomous Pedagog.
In the last 6 sem illa 12 ಗಂಟೆಗೆ ತಗೋಬಹುದು OS ಈಗ ಮೆಸೇಜ್ tomorrow extra class OS
Hope you all will have a precious afternoon. I here now request Dr. Prashant B. Hiramat, IIC convener, to welcome the guests. Over to you, sir.
Thank you, madam. Good evening to one and all present here. I, Dr. Prashant B. Hiramat, Assistant Professor, PG Department of Chemistry, Convener, Institutions Innovation Council, Arts Science Institute, Pedagog. Take this opportunity and I feel extremely happy to welcome you all to this gathering. As you all know, the Institutions Innovation Council, Arts Science Institute has been selected from Ministry of Education's Innovation Cell, MIC, Government of India to conduct impact lecture sessions on various activities. And as you all know that this is our second session and the session 1 was conducted on 24th June 2022, which included 2 lectures, the lecture 1 entrepreneurship as alternative career option and lecture 2 soft skills for career guidance through Google Meet online platform. In addition to that, today we are going to have 2 lectures under session 2, which includes lecture 1, which we just now winded up, that is lecture innovation strategies and transfer of innovations into applications. And presently we're going on for the lecture 2, that is IPR and overview and implications through online Zoom live. So today we have a dynamic personality as our resource person, Mr. Sharana Basava sir, who is patent agent, Patil IPR Associates, Faridabad, Haryana. So on behalf of Principal and IIC Institutions Innovation Council, KLE Society, I warmly welcome you, sir. I extend my warm welcome to Dr. Jyoti Kavlekar ma'am, Principal, Arts Science Institute. Welcome you, ma'am. I welcome Dr. Satisha MP, sir, President, IIC Arts Science Institute, life member of KLE Society. I also welcome Dr. Kirti S. Badagi ma'am, IQAC Coordinator, Arts Science Institute. I would like to welcome Srimati Megha Galagali, Innovation Cell Coordinator, Institutions Innovation Council, Arts Science Institute. I also welcome Srimati Pooja Malwanki ma'am, Mentor-Mentee Coordinator, Institutions Innovation Council, Arts Science Institute. I also welcome Dr. M.M. Tamboli sir, IPR Coordinator, IIC, Arts Science Institute. Dr. Jagdish Hiramat sir, ARIA Coordinator, IIC, Arts Science Institute. And lastly, I welcome all the head of various departments, IIC coordinators, faculty members, and all my dear students. Thank you and welcome you all once again. Thank you.
Thank you so much. Requesting our beloved principal, Dr. J.S. Madam, to address you all. Over to you.
Yeah, good evening, everyone. Honorable members of the Ministry of Education's Innovation Cell and AICT, respected resource person of today's session, Mr. Sharan Basav, Patent Agent, Patil IPR Associates, Faridabad, Haryana, Sri S.G. Nanjapnar, Life Member and Member Secretary, Executive Body of KLE for PU Section, Dr. Satisha, MP President for Institutional Innovation Council, and also Life Member and Member Secretary, Executive Body of KLE for Degree Section, Dr. Kirti Badgi, Coordinator, IQAC and NAC, Dr. Prashant Hiramat, Convener for Institutional Innovation Council, Mrs. Megha Galgali, Innovation Cell Coordinator, Dr. M.M. Tambori, IPR Coordinator, Mrs. Pooja Malwanki, heads and coordinators of various departments of UG and PG, and other faculty members, and my dear students. I'm really very delighted to be a part of this webinar conducted under the Impact series under the IIC program invited and supported by the Ministry of Education's Innovation Cell AICT. Today's webinar is on IPR and overview and its implications, organized by our college under IIC in association with IQAC. In fact, IPR plays an immense role in encouraging innovation and creativity for a better future. It provides certain exclusive rights to the inventors or creators of that property in order to enable them to reap commercial benefits for their creative efforts or reputation. There are several types of intellectual property protections like patents, copyrights, trademarks, and many more. So in totality, IPR is prerequisite for better identification, planning, commercialization, rendering, and thereby protection of invention or creativity. So to know more about this, IPR and overview and implications, we have organized this webinar under Impact Lecture Series. For this, we have an eminent speaker amidst us, Mr. Sharan Basav, Patent Agent Patil IPR Associates, Faridabad, Haryana. Sir, on behalf of our management, all the faculty and student community, and my own behalf, I welcome you to today's webinar, and also thank you for accepting our invitation to grace this occasion and share your thoughts. I would like to thank the authorities of the Ministry of Education's Innovation Cell and AICT for giving us an opportunity for conducting impact lecture sessions and also for supporting us with funding assistance. I also thank the management members, all the organizing team, and all my learned colleagues and students for being with us. Thank you. Thank you one and all.
Thank you.
Thank you so much, ma'am, for such a point. Moving on with, I would like to request Dr. M.M. Tamboli, IPR coordinator, to introduce our resource person, Mr. Sharan Basav. Over to you.
Thank you, ma'am. Good evening, one and all. It's a pleasure to introduce our today's resource person, Sri Sharan Basav sir. Basically, he is from Raichur district, Karnataka. Sir has completed MS in biochemistry from Gulbarga University, Kalburgi. He started his research career from National Center for Cell Science, Pune. Then he later moved to IIT Guwahati as a staff member in the Department of Biotechnology, where he served for 7 years. Since last 12 years, he's been residing in Delhi NCR and having offices in Pune and Delhi. Sharan Basav sir is a registered patent agent. He qualified patent agent examination in the year 2008 and registered as a patent agent with the Patent Office, India. Since then, he is involved with various institutes for filing their patent applications and patent proceedings in India and international applications at PCT through Patil IPR Associates. He has completed courses on intellectual property rights from World Intellectual Property Organization and cleared it with distinction. His firm has filed more than 200 applications in India and international. His firm is associated with various individual applicants, including government, private institutes within India, outside of India as well, for securing intellectual property rights. With this brief introduction, I request Sharan Basav sir to take over the session. Thank you, sir.
Yeah, thank you one and all. Thank you, Dr. Prashant and Tamboli sir and Madam Principal Madam and Pooja Madam for inviting me for this today's talk. So I hope all I am audible, Dr. Prashant.
Yes, sir. Audible.
Yes, yes.
Okay. Can you allow to
Yes,
share
sir.
the screen?
Yes, yes. Now you are a host, sir. You can share your screen.
Okay. Dr. Prashant, screen is visible now?
Yes, sir. It is visible, sir.
Okay, okay. Thank you. Yeah, well, audience is basically are the students or some experts also there, so that accordingly I will make my presentation.
No, sir, it includes mainly students of, as our college is a basic science, BSc students, MSc students are
Okay.
there, including all department faculty.
Oh, very good, very good. Okay, I will take to the students level so that anyone can understand the basics of the IPR. Okay.
Sure, sir.
Okay. So IPR means intellectually property rights. My title says that IPR, an overview and implications of this. Yeah, my name is Sharan Basu. I'm a patent agent, as already introduction given by Dr. Tamboli. And my firm name is Patil IPR Associates. Yeah. Here is the introduction. Property. Property means it may be tangible or intangible. Tangible means movable or immovable. For example, for a movable, it may be car, bus, anything. In case of immovable, it is like an asset, means a buildings, mainly it may be house or college building or industry building. All this falls under immovable property. Whereas intangible means intellectual property that you cannot touch or feel, but however, it has got more than the value of the tangible property. Intellectual property, IP. It is the term that describes the ideas, inventions, technologies, artwork, music, and literature that are the intangible when first created, but become valuable in tangible form as products. IPR allows people to own their creativity and innovation in the same way as they can own their physical property. The owner of the IP can control and be rewarded for its use, and this encourages further innovation and creativity. Intellectual property rights are the rights awarded to the individual or organizations over creative works, inventions, literary and artistic works, symbols, names, images, and designs used in commerce. These rights are given to the creators to prevent others from making unauthorized use of their property. Yeah, as already Principal Madam briefed about types of the IP. Here, these are the different types of intellectual property. It may be patents, copyrights, designs, trademarks, geographical indications, know-how, and trade secrets. What can be done with these rights? You can use it, transfer it, or share it, or you can give on rent, sell it, enforce it, donate, or collateral. Yeah, patent is an exclusive right granted by the government, state for the commercial exploitation of an invention for a limited time, and gives the inventor or patentee an exclusive monopoly of his invention. And the criteria for patent is it has to fulfill the novelty, inventive step, and industrial applicability. If any one of these parameters is not fulfilling, then that patent is invalid. If all these criteria is fulfilled, then controller of the patent will grant the patent. The patent's law practice. The purpose is to, we have to, as an inventor, you have to disclose the invention, and patent office will give you the protection for that in terms of patent grant. It is for 20 years from the date of filing. It's like a give and take. You have to disclose the invention, and patent office will give the rights for 20 years. A patent gives an inventor the right for a limited period to stop others from making use or selling an invention without the permission of the inventor. Patent rights are territorial. Means it's like a jurisdiction. If you are filing in India, your rights only it's limited to India. Patents can be bought, sold, mortgaged, or licensed to others. Patents also benefit the people other than the inventor, since patent database form an enormous source of information. It stops reinvention. On expiry of period of protection, the benefits of the invention totally goes to the public domain. Dr. Prashant, if the students has any query or anything, they can stop any time.
Sure, sir. I will make it in the chat box so that if they want like to mention anything, they will put it in the chat box. Sir.
Yeah,
Sure.
my objective is to students should understand about what exactly IPR and who can apply. And I mean, many people they think that if there is a
Right, sir. Sure, sir.
okay, all right. Patents top 10 points to know. There is no such thing as an international patent or world patent. Patent applications are not the same as granted patents. Patents are examined, they are not peer reviewed. The applicant or assignee of a patent may not be the actual holder of the patent rights. Patents have a limited lifetime. Patents are rights with geographic boundaries. Infringement of a patent is generally a legal matter between parties. Claims define the limits of a patented invention and the boundaries of the patent rights. A patent does not guarantee that anyone will license the invention. Patent rights are exclusionary rights. Okay, I mean, as I was saying, some students may be thinking that only big inventions can be filed for a patent. You see, in 1849, patent for safety pin issued in April 10th, 1849. A New Yorker, Walter Hunt, invents a handy device application number so 6281. I mean, as simple as safety pin, they have filed in almost you see 150 years back. Exclusive privilege given to the applicant by the government for a limited period to exclude others from making, using, or selling the invention without permission in return to the complete disclosure of the invention. What are the roles of IPR and why this patent system? It streamlines the science and technology databases. It encourages for improvement of technology. It provides a reward as exclusive rights for the disclosure, for making the profits or earnings royalty through putting the invention into practice, transferring into public property after expiry of the term or cessation of the patent. And what are the advantages of the patent? It avoids duplication of research, keeps abreast with latest development in different fields of technology. It helps industry to improve existing technology to produce cheaper and better products. It serves as an indicator of achievements in research and development institutions and ability of individual researcher. It records the information for future reference. Few examples I would like to mention here. These are the simple inventions, but they got huge profits. For example, a ring pull can. The inventor licensed the patent to Coca-Cola at 1/10th of a penny per can. Almost 1,48,000 UK pounds per day as royalty is earning till date. And another example is just paper clip. 400 paper clip patents are there. It looks very simple, but almost 400 patents filed on this. It valued almost $80 million. Spin brush. 4 inventors sold to Procter & Gamble for $475 million. Almost rupees 3,000 crores. Yeah. Now I am just giving other types of intellectual property rights, that is industrial design. The features of shape, configuration, pattern, or ornament, or composition of lines, or color, or combination thereof applied to any article in 2D or 3D or in both forms. These falls under industrial design. For example, you can see the earrings. Okay, these are the different types of gloves. They have got the protection for the design. An industrial design is that aspect of a useful article which is ornamental or aesthetic. The owner of the industrial design can prevent unauthorized copying or imitation of the design if it is registered. A design must be new or original and industrially reproducible in order to become eligible for protection under industrial design law. Yeah, these are the some of the trademarks. Tata, Bata, and Blue Dot, DHL, you can see. Trademark is a word, a name, symbol, or device which is used in trade with goods to indicate the source of the goods to distinguish from the goods of the others. And here, service marks like Blue Dot, DHL. Service mark indicates the source or origin of service. For all practical purposes, trademarks and service marks are subject to the same rules of validity, use, protection, and infringement. A property mark, a mark used for denoting a movable property belongs to a particular person, is called property mark. Then comes the geographic indications. A geographical indication is a sign used on goods that have a specific geographical origin and possess qualities or a reputation that are due to the place of origin. Appellations of origin are specific types of geographical indications. An appellation of origin is a more precise geographical indication which specifies that the product in question has certain qualities and that those qualities are due essentially or exclusively to its place of origin. Geographical indications are place names used to identify the source of origin and quality, reputation, or other characteristics of products. For example, Ilkal Sari, Dharwad Peda, Badgi Mirchi or Chili, Tirupati Laddu. These are the some of the Indian GI products. Yeah, another type of intellectual property right is copyright and related rights. It provides its holder the right to restrict unauthorized copying, reproduction of an original expression, that is literary work, movie, music, painting, software, etc. Copyrights are exclusive legal rights on creativity, and it has got bundle of rights, moral and as well as economic. It protects originality of expression and not ideas. If it is an idea, it falls under patents. National in nature, a domain, a literary and artistic works, writings, music, works of the fine arts, paintings and sculptures, technology based computer programs and electronic databases. Acquisition of copyright is automatic by itself and it does not require any formality. However, certificate of registration of copyright and the entries made therein serve as a prima facie evidence in a court of law with reference to a dispute relating to ownership of copyright. In the case of original literary, dramatic, musical, and artistic works, the 60-year period is counted from the year following the death of the author. In the case of cinematograph, films, sound recordings, photographs, posthumous publications, anonymous and pseudonymous publications, works of government and works of international organizations. The 60-year period is counted from the date of publication. It is subjected to certain conditions. Use is permitted for research, study, criticism, review, and news reporting, a library and schools, legislatures, without specific permission of the copyright owners. Yeah, now comes the trade secret. It is a formula, pattern, physical device, idea, process, compilation of information or other informations that provides the owner of the information with a competitive advantage in the marketplace and is treated in a way that can reasonably be expected to prevent the public or competitors from learning about it. In India, we have no legal provisions to protect the trade secrets for the time being. What are the requirements for patent filing? If they have any questions, I am happy to take the questions, Dr. Prashant.
Yes, sir. Sure, sir. So if they have, definitely they will put it in the chat box, sir. And I will also encourage. Both students and faculty, sir.
Okay. So can I continue?
Yes, sir. Please continue, sir.
Okay.
Thank you.
Yeah. What are the requirements for patent filing? Patentability requirements are, I mean, as I said, according to the Patent Act, invention, it defines or the definition of the invention is, it means a new product or process involving an inventive step and capable of industrial application. And it should fulfill the inventive step. What it does, I mean, what does it mean? It means a feature of an invention that involves technical advancement as compared to the existing knowledge or having economic significance or both. That makes the invention not obvious to a person skilled in the art. It should be capable of industrial application or industrial use. In relation to an invention, it means that the invention is capable of being made or used in an industry. And some of the points I would like to mention here, what are the not patentable inventions? I mean, as per Section 3 of the Patent Act 1970, if a frivolous invention, an invention which is frivolous or which claims anything obviously contrary to well-established natural laws, for example, water as a petrol without any mechanism, this type of claims they will not allow. It is contrary to the natural laws. Or against any public order and morality. An invention, the primary or intended use of commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to a human, animal, or plant life or health, or to the environment. Some of the examples like embryonic stem cell culture, sex determination technology. However, in India, it is not allowed. That's why we don't give patents in India. In some of the other Western countries, they are allowing sex determination, so they can file the patent over there. A method of adulteration of food, drug, medicine. This type of contrary to the public will not be granted a patent. And discovery. The mere discovery of a scientific principle of the formulation of an abstract theory or a discovery of any living thing or non-living substances occurring in nature. Discoveries are not patentable. Inventions are patentable. There is a clear-cut difference we have to prove from the invention to a discovery. Isolated microorganism or chemical from the nature is not at all allowed. However, if you are using any recombinant, a microorganism, that type of things may be allowed. Here you can see the difference between the invention and discovery. Thomas Alva Edison, he invented the bulb, whereas Alexander Fleming, he discovered the penicillin. So only inventions are allowed for the patent, not the discoveries. A new form of known substance. The mere discovery of a new form of a known substance which does not result. One second. The mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property of new use for a known substance, or of the mere use of a known process, machine, or apparatus, unless such known process results in a new product or employs at least one new reactant. Here it means that, for example, if you have a paracetamol tablet, and all we know that for fever, etc., we are using, but if you are coming up with a new application, only for the application they won't grant the patent. It has to be it should have any new efficacy, then only it will be allowed. For example, for the purposes of this clause, salts, esters, ethers, polymorphs, metabolites, a pure form, particle size isomers, complexes, combinations, and other derivatives of known substance shall be considered to be the same substance unless they differ significantly in properties with regard to efficacy. A new form, isomer, salt, or any biomolecule, and if there is just an admixture and no synergistic effect, it is also not allowed. A substance obtained by mere admixture, resulting only in the aggregation of the properties of the components thereof, or a process for producing such substances, polyherbal composition, etc., will not be allowed until unless it has to prove by some synergistic effect. And arrangement and rearrangement of devices. The mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. For example, umbrella with fan or umbrella with torch. You can see examples like a bucket fitted with torch. These two are having independent functions. So this type of inventions are not allowed. And a method of agriculture or horticulture. A method of producing improved soil with nematodes or vermiculture. These are not allowed. And method of treatment of animal. Any process for the medicinal, surgical, curative, prophylactic, diagnostic, a therapeutic or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. For example, method of art surgery. So this type of treatment or method is not allowed. Plants or animals or their parts. Plants or animals in whole or any part thereof other than microorganisms, but including seed varieties and species, and essentially biological processes for production or propagation of plants and animals. These are not allowed under the Patent Act. A crossing of the plants to make hybrid, these are not allowed. And computer program per se, a mathematical or business method or a computer program or algorithms or softwares, these are not allowed under the patent, but however they can go for the copyright. Copyright or design matter, a literary, dramatic, a musical or artistic work or any other aesthetic creation whatsoever, including cinematographic works and television products, television productions. A mere scheme of rule or method of performing mental act or method of playing game. This type of inventions are not granted under the Patent Act. A presentation of information and topography of integrated circuits, these are not allowed. Topographies are allowed under the copyright. And traditional knowledge. An invention which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components. For example, turmeric powder in wound healing. In US, they have filed, but after the objections, they have rejected the patent. This neem oil formulation as pesticide or insecticide, European patent application 04362557, they have filed. Section 4. This section 4 of the Patent Act talks about atomic energy related inventions. These are not patentable. No patent shall be granted in respect of an invention relating to atomic energy falling within subsection 1 of section 20 of the Atomic Energy Act 1962. For example, if you are creating any RDX bomb or anything, that type of inventions are not allowed. Okay, now we talk about document requirements. What are the documents and how to begin? First is application form, form 1, and next is form 2. I will tell in detail in my coming slides. Form 2 is basically for provisional or complete specification purpose, and form 3 is statement of foreign filing details, and form 18, this is for the request for examination. These 4 are compulsorily one has to file during the application. Yeah, form 1 looks like this. Here, what are the details we have to give? One is applicant details. It may be a natural person or other than the natural person. Other than natural person means like college, industry, anything. Natural persons means individual names. And next comes the inventor. Inventor always it is natural person, because college or any organization themselves or it itself cannot invent. There should be some human beings involved for the inventions. So their names should appear here. Name, nationality, and address. And then address for correspondence of applicant or authorized patent agent. This is very important for the communication purpose, whom to correspond, for example, first examination report or subsequent examination report, hearing notice, all that will be sent to the email ID of the address for correspondence mentioned here. And then priority particulars of the application filed in the convention country. Suppose if you have filed in UK or US, then you have to give the priority application number. Particulars of the patent cooperation treaty. In case if you have filed the international application at PCT, that priority date you have to mention here, and the national phase followed by the national phase. And here is the declaration. Here true inventors, they have to sign this particular thing, a declaration by the inventor. This is must. And in case if you are using any biological material, you have to take the invention as disclosed in the specification uses the biological material from India, and the necessary permission from the competent authority should be submitted by me or before the grant of patent to me and or us. This part you have to tick. Some of the other things like there is no lawful ground of the objection of the grant, and if the inventor or applicant is a minor, then a legal representative of the true or first inventor has to be assigned here. Okay, and then following are the attachment with the application. As I said, the complete specification or provisional specification. and drawings, number of pages and number of claims, all those details will be required to calculate the fees. And if it is a translation of priority document, then specification, international search report, all these things we have to provide. Then statement and undertaking on form 3. I mean, power of authority. Suppose if you are hiring an attorney like me, then you have to provide the power of authority to act on your behalf. And declaration of inventorship on form 5. If there is any additional inventors after your provisional filing, you have to mention in the declaration of inventorship on form 5. Sequence listing in electronic form. It may be earlier they used to use floppy disk. Now there is a software available. We have to mention the sequences there and we have to upload. And fees will be calculated accordingly. Up to 30 pages, only 1600 rupees, and 10 claims. If it is more than 10 claims and 30 pages, each claim will be charged additionally 320 rupees, and for additional one page, rupees 160 will be charged. Yeah, now I am showing you the form 2. Here you have to disclose your invention. It may be provisional or complete specification. For example, you may be thinking that what is provisional and what is complete. Suppose you have got an idea and you want to protect that idea quickly, you can go with the provisional. Though you have not performed subsequent experiments and even you have not gathered the data, however, you can mention your all idea in this one drafting, and you can protect that idea. And within 1 year, you have to perform and produce the data in the form of complete specification. Maximum time allowed is 12 months. Before that, you have to submit the complete specification. Provisional, in case of provisional, you don't need to write the claims. But in case of complete specification, you have to come up with the claims. Here, this form 2 starts like this: title of the invention. You have to mention the title, then applicant details, name, nationality, address, and then the preamble of the description. For the provisional, you have to say that the following specification describes the invention. For complete, you have to mention the following specification particularly describes the invention and the manner in which it is to be performed. Then follows a description. You have to describe your complete invention from the background of the invention and what was the problem, how you have found the solution, all the details you have to mention in description. Then comes the claims. Claims are the art of the invention, and it is a legal, a techno-legal document. So one has to draft without infringing others' inventions. And then finally, date and signature. Then last comes the abstract of the invention. It has to be less than 150 words, and if there are any figure, a representative figure can be mentioned in the abstract to understand better. Okay, patent specification. Here, as I said, there are two types of specification. One is a provisional specification and another is complete specification. It should describe the nature of the invention and contain a description of essential feature of the invention. No need to include claims and details of the manner in which it is to be performed. Whereas in case of complete specification, these are the bullet points required in the draft. One is title of the invention, field of the invention, background of the invention, advantages and or uses of the invention, object of the invention, statement of the invention, a detailed description with drawings, examples, if any, claims and abstract. Yeah, what is complete specification? It should be fully and particularly describe the invention. It should disclose the best method. And if you are using any biological material, you have to deposit in International Depository Authority under Budapest Treaty, and disclose the source and geographical origin. If you are using a biological material from India, you have to obtain the permission from National Biodiversity Authority. End with one or more claims. And then comes the fee structure. For the natural person or startup, filing fees is 1,600 rupees, and another important or another compulsory fee is that is a request for examination, that is 4,000 rupees. For small entity, now the small entity they have removed. Only two options are there. It may be a natural person, a startup, and other than the natural person, or a bigger company, you can say. Fees is 8,000 and 20,000 respectively. And if you are filing offline or physical filing, a 10% additional fee you have to make. For expedited examination, there is a provision in India for startups. And if you are filing a PCT application and if you are mentioning India as your international search authority, then also you can go for expedited examination. And one more is recently they have introduced in September 2021. If any one of the applicant is a woman, then one can go for a expedited examination. That advantage one can take in their team if they have any one woman applicant. And for Form 9, this is for early publication. If you file Form 9 with along with the fee of rupees 2,500, your application will be published within 1 month. Otherwise, it will take at least 18 months. After the 18 months, your application will be published in the Journal of Patents. Okay, and after filing this examination, examiner will examine your application and they will issue the first examination report. If you file Form 18A, that is called expedited examination. In that scenario, your examination report you will receive within 1 month. In the normal cases, it will take at least 2 to 3 years. If no objections after 6 months of publication, it will be granted. And if you go by expedited process, early publication, then expedited examination request, you may get the patent grant even within 8 months to 10 months. Yeah, then comes who can file, either alone or jointly, by any person claiming to be true and first inventor, by any person being the assignee of person claiming to be true and first inventor, by the legal representative of any deceased person who can immediately before his death is entitled to make such application. And where are the offices? And suppose if you are in Karnataka, where which office you have to choose? Here is the jurisdiction. There are 4 offices in India: Mumbai, Chennai, New Delhi, and Kolkata. And territorial jurisdiction is mentioned if Maharashtra, Gujarat, Madhya Pradesh, Goa, Daman, Diu, Dadra and Nagar Haveli, all these states will have to file in Mumbai office. And Andhra Pradesh, Telangana, Kerala, Tamil Nadu, and Karnataka, Pondicherry, Lakshadweep, Minko, and these Andaman Islands, all these have to file in Chennai. And northern states like Delhi, Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, and Uttar Pradesh will have to file in a New Delhi office. And remaining states, all these northeastern state, West Bengal, all these will file in Kolkata. Okay. Now, patent application processing means proceedings. First, you will file the patent application, then comes the publication. If you have filed early publication within a 1 month, you will have the publication. In the normal route, after 18 months, your patent application will be published. And there will be a 6 months period from the publication to examination. This is called pre-grant opposition. If any person after seeing your publication, they come to know that that invention is copied or already filed by someone, they may come up with the proof that my application is earlier and don't allow or don't process this application like that. They can oppose in front of the controller. If there are no pre-grant opposition, then such application will be examined by the examiners at the patent office, and they will issue the first examination report, that is called FER, or subsequent examination report. If they are not convinced, then they will call for a hearing. It may be through a video conferencing or physical hearing. Then you have to one-to-one, if there are any query, you have to answer them. Then after acceptance of all the queries resolve this one, then they will grant the patent. If they are not satisfied, they will refuse or reject the grant. Then finally, this granted patent application will be published. And then if there are any post-grant opposition, that will also take place. I mean, as I said, in the normal route, initial after filing, you have to wait for 18 months for the publication, and 3 months for almost 6 months for the pre-grant opposition, and then grant. So all this will take around 2 to 3 years. Whereas in case of early or expedited examination, within 8 months, you will have the patent grant. Yeah, now I will talk about just 1 or 2 slides. I think, Prashant, how much time they can have? Okay, I will talk about international filing, that is Patent Cooperation Treaty. What are the advantages of the PCT? It means a Patent Cooperation Treaty. Seeking protection simultaneously means you can protect if you are filing in India or as a PCT application, almost 153 countries, your priority date will be protected, and more decision time to enter the national phase. You will have 30 months or 31 months time to enter into different national phase applications. For example, US, UK, or Japan, China, to decide whether my invention is really worthy to go to all these countries. You can decide in that period. Strength of invention through search and examination. Basically, they do international search. Then they give international search report, that is called ISR. Based upon that, you can decide where your invention stands. And opportunity to have foreign counterparts. And if your invention is really good, even in foreign, other countries, they will approach you for licensing, or they would like to jointly apply in their particular country by sharing the royalty. And what are the advantages of PCT? By filing a single application, international application, all 153 countries priority date will be maintained with a single patent office, that is a receiving office or RO, in one language, having effect in each contracting state. One formal examination. So all these will be in a single window system, and one search report, international searching authority. They will do the search and they will issue the search report. And there will be an international publication from the International Bureau of World Intellectual Property Organization. One optional preliminary examination is also available if the applicant wishes to have a preliminary examination, they will do the preliminary examination on payment basis. And after having the patent, what to do and what are the suggestions? You can share the benefit of patent system or utilize the resources through organized R&D activities, capture the global market judiciously, earn profit through a protected market. Here there are many students or the audience, that's why I have put these slides. What are the opportunities or a career in patent or IPR field? One can go for apply for the examiner positions from in the patent office. To become an examiner, what are the requirements? They should have MSc in various subjects or equivalent, or BE, BTech in various subjects are equivalent. And there will be a direct recruitment. And to become a patent agent, what are the qualifications and who can become patent agent? He or she should be a citizen of India and above the age of 21 years, and he or she should have degree in science, engineering, technology, and additionally pass the prescribed exam. Basically, this Patent Office of India will conduct the patent agent examination. One has to qualify that, then they are eligible for the registration as a patent agent. And intellectual property appellate board courts, there are many positions available. Those who are having depth knowledge in this field, they can apply there also. And these sources of information, one can go to the ipindia.nic.in website or wipo.int, EPO, USPTO, etc. In these sites, if you want any details about the patent system, all the databases are available here. Okay, this is my last slide. It is not the strongest of the species that survive, not the most intelligent, but the one most responsive to change. This is from the Charles Darwin. I thank you one and all. If you have any questions, I am happy to answer. Madam, I think, yeah, please unmute yourself, ma'am.
Okay. Yes, sorry, I was muted. Yeah. This is open for discussion. Anybody, if you have any clarification, then please ask our resource person. It is open for discussion. Or you can put your message in a chat box. So I hope the session was too clear and interesting for the participants since they don't have any clarification.
Okay.
Thank you so much, sir, for taking your time out and briefing us about IPR, which is one of the sources of security for intangible properties, which are still open to the public and can be quickly replicated by anyone. It is the rights given by persons over the creations of their minds, inventions, symbols, names, and images used in commerce. Sir also highlighted about the types of IPR: patents, design, copyright, trademarks, and trade secrets. Thank you so much, sir. It was a wonderful session. Thank you so much for enlightening our students with insights you have about IPR.
Yeah, thank you, madam. And even if the students, they have any doubts or anything, you can share my number and email ID.
Yes,
and,
sir, sure, sir.
And anybody can contact me for any type of doubt if they have, for protecting their IPs.
Yes, sir, sure, sir. You just share with us your email ID as well as phone
Sure,
number.
sure. I think it is there
Circulate.
in my first slide.
Okay, sir.
Just one second. Yeah. My number is 95822
1 second. 95822
89868.
89868.
Yeah.
I'll surely circulate to students, those who are interested in patenting and everything, they'll just call you, sir.
Yeah. Okay. Okay.
Thank you so much, sir.
Okay. Thank you very much.
Thank you, participants, for your active participation. We shall wind up our session here. Thank you.
Thank you.